Hello again. I am attorney Benjamin Beck, and this is the Beck Law Office's weekly question answer. If you have any questions, you can submit them to me at ben@becklemonlaw.com. This week's question is I have a settlement offer from the manufacturer. I haven't filed a lawsuit. Should I accept it? Well, that really depends on your specific situation and your specific circumstances. I can't really answer that generally, but what I can say is, there's a lot of cash and keep, they call it, settlement offers that happen before a lawsuit is filed. So the manufacturer could be offering you, I don't know, $3,000 or $4,000 to sign a settlement agreement and release and basically go away. Now, depending on what your situation is, I don't know if you're planning on trading the vehicle quickly and getting rid of it and not driving it for the next several years. Maybe that's right for you. But if you are considering keeping the vehicle and driving it over time, then chances are you can still use it under the warranty after accepting a low ball settlement offer like that. But if you did want to pursue a lemon law claim because more prevalent defects or the defect occur, or the frequency of the defect increased, or more serious problems came up which actually do qualify the vehicle as a clear lemon, then you're basically cutting yourself off at the feet, because you've likely signed a settlement agreement and released the manufacturer from any sort of future liability in exchange for that cash. So, depending on your circumstances and what the offer is granted, you may not want to take that. But if, for example, you contact the manufacturer, if you called them and you asked for them to buy back your car, and they, before a lawsuit or a lawyer's involved, and they do that, then depending on what that offer is, how the math is, then it might be a good result for you. And that's, as long as it's compliant with the statute, and that's what they're offering before the lawsuit's filed. Really, that's what they're supposed to do. So that might be a good offer for you to take. Granted, you'd need a lawyer to probably look at the actual numbers to make sure that they were appropriate, and that they were giving you the statutory refund. But those are kind of the options that you deal with. Now, keep in mind, a lot of firms really focus on a pre-litigation practice, and they'll do a demand letter for you. The manufacturer doesn't offer a repurchase; they offer you some lowball settlement, and the firm doesn't want to file a lawsuit because your case isn't strong enough to sue in court on. And then they'll want you to either accept the settlement or hopefully wait and come back when your claim is better. But if there's any sort of pressure for you to settle that, those are things you need to take into consideration. Um, I wouldn't want a potential client to accept a lowball settlement, knowing that they're going to keep the car for several years, and there's a risk that the problems would return or not be fully resolved. Um, and then lo and behold, their lemon law claim becomes very strong, but they're barred because they signed a settlement agreement and release saying that they can't sue that manufacturer. So those are things that I think about, and depending on your situation, those might affect how you want to proceed. But again, this would be something that you're probably going to run by a qualified California lemon law attorney like myself. Again, I do free consultations. Feel free to give me a call, send me an email if you have any questions. But that is the Q&A for the week. Feel free to submit your questions if you'd like any of those answered in my weekly Q&A. Have a good week, everyone. Thank you.